Before us on this case, and Mr. Noel, you are for the appellant. Do you wish to reserve 5 minutes of time?
Yes, Your Honors. Thank you. Good morning. May it please the court. My name is David Noel, and I represent the appellant in this case, Heritage Property and Casualty Insurance Company, and would like to request the 5 minutes for rebuttal, please.
Yes, sir.
Our appeal here today is seeking reversal of the trial court's order compelling appraisal on two different alternative legal bases. Our first reason for reversal is that the plaintiff in this particular case, the assignment of benefit mitigation company, waived its right to appraisal. And the second argument is that in the alternative, if there was no waiver, then the trial court erred by not holding an evidentiary hearing and making factual findings regarding compliance with post-loss obligations. With respect to the first argument, waiver, there are multiple factors supporting that. The first one is the passage of time. Heritage made its coverage determination that this Hurricane Irma claim was below deductible on November 6th of 2017. And it was not until December 12th of 2019, over 2 years later, that the plaintiff moved to compel appraisal. And that was the first instance of any request for appraisal. Now, the plaintiff has argued that, well, as the AOB company, it's not really their fault for the lengthy delay. It's more on the insured because they didn't take any steps to submit a supplemental claim or otherwise raise the appraisal issue. The problem with that,
no, on the issue of the passage of time, what is Heritage position as far as Superior makes a statement? I don't think this is sworn or anything, but it says that it sends Heritage a 14-day demand and that there's no response. What is Heritage position on that? Because I'm not sure that I saw that from the record. Other than they say that they didn't get anything between this period of time. Are they denying that they received the 14-day demand?
Yes, Your Honor. Heritage's position is that they received nothing between the time of the original coverage determination and the time that suit was filed. And it's also very interesting that the record does not include any copy of this alleged 14-day demand by the plaintiff. It's simply not out there. It appears in the record as argument of counsel in one of their papers, but there is no evidence in the record to back that up.
Okay, but there wasn't any sworn testimony, right? I mean, this wasn't, because it wasn't an evidentiary hearing. I mean, that's one of the complaints that you have. And so I guess my question is that factor relevant to your waiver analysis? If one party is saying, hey, but I sent a demand, and Heritage is saying, well, I never received it. Don't we have to factor that in and lean more towards sending it back for an evidentiary hearing?
Your Honor, I would agree that's definitely a factual question, and had the trial court held an evidentiary hearing on both the post-loss obligations and also the waiver issue, we'd have a much more developed record. But our position would still be that based on what is currently in the record, that is legally sufficient for a finding of waiver here. But to the extent that there is that factual question, were it to factor in and be sufficient to tip the scales one way or the other, that's another ground why we would need an evidentiary hearing here to flesh out all these facts, in particular what happened pre-suit and what was going on with the insured and the plaintiff here, the AOB company. But strictly based on what's already in the record, it's sufficient for a finding of waiver because of the over 2-year delay between the date of the coverage determination and the date of the motion to compel appraisal, and the fact that the plaintiff here stands in the shoes of the insured. The assignment of benefits is only assigning the right to collect benefits under the policy. It's not assigning away the obligations the insured has. So if the insured failed to comply with its obligations, such as prompt notice of this large supplemental claim, that's going to be held against the plaintiff in this case, regardless of the assignment. And that's reflected in the Ifergain case from a third DCA, If the rule were any different, it would simply allow insureds to wait an extremely lengthy time period.
Let me go back. Let me follow up on something with respect to the evidentiary hearing, should we remand. So my question is, during the hearing in which, and it's very short, when the court actually grants the appraisal, right? I don't see in that record at that hearing where anyone raised the objection, well, Judge, hey, you need to conduct an evidentiary hearing. I see it was addressed at one of the prior hearings, but during that actual hearing where the motion is ruled upon, I don't see where it is raised. Can you address that for me as far as preservation?
Yes, Your Honor. I would direct the court to page 206 of our
Right.
appendix to our initial brief, which is A206, and that is the hearing on the motion to compel appraisal. And at that hearing, Heritage's trial counsel, after plaintiff's counsel had requested appraisal and the court turned it back over to Heritage's trial counsel, Mr. Rubinton stated he's not entitled to it, referring to the appraisal. One, he's over the phone. He's not going to be able to meet his burden. It's an evidentiary matter, and I have the case law judge, if I may approach. So there was a direct argument placed in front of the court that, hey, this needs to be an evidentiary hearing. It is an evidentiary question. And that's also reflected in all the case law. And the plaintiff, as the party filing that motion and having it heard before the court, the trial court, it would be incumbent on the plaintiff to set the right type of hearing and appear with evidence, appear in person, if necessary, not telephonic. But it wouldn't so much be Heritage's burden to sort of instruct the plaintiff in the law and tell them they needed to set an evidentiary hearing. The objection was raised at that hearing on January 24th of 2020 on the motion to compel appraisal. Going back to the waiver argument, just briefly, Your Honors, in addition to the lengthy passage of time, there were also multiple pleadings filed in this case. The original complaint said nothing about appraisal. It was strictly for breach of contract. And then the amended complaint, which was filed approximately 6 months later, also strictly limited to breach of contract and says absolutely nothing about appraisal. The interesting thing about the amended complaint is that it was filed after the motion to compel appraisal. So you would think it would at least slip something in there referencing appraisal, but it's absolutely silent on that point. Now, the plaintiff has raised the argument, and this is completely accurate, that the order dismissing the original complaint gave the plaintiff leave to amend with respect to specific paragraphs of that complaint. It was paragraph 16, 17, and 18. But that was based on what was argued at the hearing on Heritage's motion to dismiss, and ultimately what Heritage had request clarification on in that particular complaint. There was nothing from the plaintiff that said, Judge, we also want to add appraisal to our pleading so we can properly frame the issues in this case. And had the plaintiff requested that relief to put it into the amended complaint, certainly there wouldn't have been any basis for the court to deny that. So there was absolutely an avenue there for the plaintiff to frame appraisal in their amended complaint, and it just didn't happen. Also supporting a finding of waiver is the discovery that was propounded by the plaintiff in this case. With the original complaint, the plaintiff propounded requests for production, requests for admissions, interrogatories, and a notice of taking deposition of Heritage's corporate representative. These were all greatly detailed discovery requests, and they never mentioned anything about appraisal. They didn't ask, do you oppose appraisal? What's your legal basis for not going to appraisal? Nothing. It was pure breach of contract discovery, showing that this case all along was simply about breach of contract. And even more significantly regarding discovery, the plaintiff did obtain an order in this case dated February 3rd of 2020. Now, this is the same order that denied Heritage's motion to dismiss the amended complaint, but also reflected in that same order is that Heritage must answer all those discovery requests within 20 days. And that's at page 217 of the appendix to our initial brief, A217. Now, this wasn't argued at the hearing. It's not reflected in the hearing transcript, but it does appear in that order. So that's consistent also with the plaintiff seeking discovery and wanting to move forward on their breach of contract claim. They simply were not focused on appraisal, and as a result, they acted inconsistently with the right to appraisal. And as a matter of law on this record, they waived the right to appraisal.
Mr. Knoll, can I
Yes.
take you back to something that you said right at the beginning of your argument? You said that coverage was admitted fairly early on, before before the lawsuit was initiated. But in your motion to dismiss, you said that coverage had not yet been determined and that the investigation was ongoing. So at what point was coverage definitively acknowledged, and how was that communicated?
Yes, Your Honor. So what we have here is two separate claims. We have the original Hurricane Irma claim where coverage was admitted and it was determined to be below deductible back in November of 2017. And then time goes by, over a year and a half goes by, and then Heritage's first notice of a new supplemental claim is this lawsuit seeking hundreds of thousands of new dollars allegedly caused by Hurricane Irma. So the dichotomy between those two is that the passage of time and the greatly increased scope and dollar amount means that the lawsuit was the supplemental claim. And since there was no notice of that supplemental claim before suit was filed, Heritage was denied the opportunity to investigate that supplemental claim.
Okay, so it was solely coverage as to the supplemental claim.
Exactly. The initial coverage determination was solely for the original, and the dispute now that's being sent to appraisal by the trial court is solely the supplemental insurance claim. And we know it's a supplemental claim because that language is defined in the Heritage policy at page 41 of our appendix to our initial brief. The Heritage policy states that supplemental claim or reopened claim means an additional claim for recovery from us for losses from the same hurricane or other windstorm which we have previously adjusted pursuant to the initial claim. So it's the same windstorm, Hurricane Irma. It was previously adjusted back in November 2017, and now there's a supplemental claim that comes to us through a lawsuit for the first time, and that's what the trial court is sending to appraisal. That segues into why an evidentiary hearing was needed on the post-loss obligations. There are multiple cases that say the post-loss obligations must be complied with as to a supplemental insurance claim. We cited State Farm versus Hernandez from the Florida 3rd DCA. There's also the case of United Property versus Concepcion, also from the 3rd DCA. But what didn't happen here and should have is that Heritage was not given prompt notice of the supplemental claim before being put into an adversarial lawsuit. And the policy does require prompt notice. And that had a cascading effect on the rest of the claim and the rest of the case, because Heritage was denied the opportunity to request documents, take an examination under oath, reinspect the property. And certainly that was a complete lack of cooperation with allowing Heritage to investigate that supplemental claim. Now, the reinspection did ultimately occur in suit after Heritage moved for leave to enter land. That was performed on January 9th of 2020, but only a few weeks later, the trial court compelled appraisal. So Heritage was never able to complete adjustment or investigation of the supplemental claim, and therefore no coverage determination was issued on that supplemental claim, which means it could never go to appraisal because there would have to be an amount of loss dispute first. If we don't get the opportunity to make that coverage determination, we don't know if it would have been a full denial of the supplemental claim, which means it's not appropriate for appraisal, or if it would have been some portion of it being paid, in which case there would be the amount of loss dispute, or potentially Heritage could have issued a payment that was sufficient to the plaintiff and appraisal and the lawsuit never would have occurred in the first place. So that's why it's so important that these post-loss obligations are complied with before the case goes to appraisal. Otherwise, you don't really have a proper exchange of information to trigger a dispute on the amount of loss. Now, the plaintiff has argued that there's enough in the record and the trial court had enough material to rule as a matter of law that there was full compliance with the post-loss obligations. That's really not.
No, just to let you know, you're now coming into your 5 minutes.
Okay, very briefly, Your Honors, there's a clear question of fact here on compliance with the post-loss obligations. Counsel for the plaintiff in the trial court stated that they had strong disagreement with Heritage's version of the facts. And there was also, as the court has brought up here today already, the question of, well, was there that 14-day demand or not? There's no proof in the record and Heritage never received it. Thank you, Your Honors.
Okay, you'll have 4 minutes left, Mr. Noel. And Mr. Rosales?
Thank you. May it please the court, Kurt Rosales with Vaca Law Group on behalf of Superior Contracting Environmental Specialties. We'd ask the court to affirm the order granting appraisal. So I guess, we're basically here on two, what I view as pretty distinct issues. The first being waiver, and then the second being the need for an evidentiary hearing. So I'll start with waiver. As far as waiver is concerned, in order to waive a right, you have to intentionally waive this known right. And the case law is pretty clear that in order to do so, you need to engage in, quote, significant litigation activities.
Let me ask you this, Mr. Rosales. Would you say that the appraisal process and arbitration have some similarities between each other in terms of alternative dispute resolution?
I believe they do. In fact,
okay.
Some of the case
with that in mind, there is some developed law on waiving arbitration that, if you start engaging in litigation activity, the law can be kind of harsh on whether or not you can continue to enforce an arbitration provision. You seem to be suggesting that, well, there's a line out there somewhere that we say there's a waiver, and I'm trying to figure out for purposes of appraisal where that line is and how we could definitively tell trial courts, hey, this far and no farther. You can allow this amount of litigation activity, but no more than that for purposes of appraisal, given kind of that backdrop of arbitration. What are your thoughts on that?
Sure, and while I agree arbitration seems to be more strict in that regard, I think that there's case law that kind of already sets these parameters, and it may not be as definitive of a line as you maybe perhaps you'd like to draw.
But that's a problem, right? Because waiver is very much a binary operation. Either you are allowed to exercise a right or you are not. And so it seems to me that we ought to be striving for a clear demarcation between when that occurs.
Sure. And, so far, I think the best case that we have as far as appraisal goes would be the Raymond James case out of the Supreme Court in 2005. And I'll just read you. It basically says that the courts should look to a few different aspects. Look to the length of time that lapsed between the admission of coverage and then the plaintiff's claim for appraisal. And then number two, to evaluate the actions that the plaintiffs took during that time frame. So I think that even the Supreme Court has not, or has, not as of yet created such a definitive line. I think they leave it to trial judges to make that determination. And I think that's what happened in this case.
Well, but is that a problem? I mean, given what I said earlier, that, the way waiver operates, it is an all or nothing occurrence. I mean, you are either, you had a contractual right, now you have lost it. Let me give you another analog and see what your thoughts on this. Yeah. In the realm of personal jurisdiction, if you were to raise a defense of personal jurisdiction, if you do anything inconsistent with that.
Right.
I think some people would say the law is merciless on it,
Yeah.
which is why defendants have to be really, really careful about what they do when they assert that kind of defense, because if you do anything inconsistent with it, you've lost it. Why should we treat arbitration appraisal, or in this case appraisal, any different? In other words, look, you have this right. It is a right that is the contractual right is meant to be exercised on the front end before you get any further in litigation. Why shouldn't we, why is it unreasonable to hold a party that would assert the right to appraisal, hold their feet to the fire and say, listen, if this is a pre-litigation process, if you engage in litigation, that is so antithetical and inconsistent with the exercise of the right that we are going to deem you to have waived it. Why is that an unreasonable place to draw the line?
As far as personal jurisdiction goes, I mean, that is in my view, that is a right that is granted. That's like almost like
it has a constitutional dimension. Yes,
exactly.
That is a fair distinction.
It's a constitutional right. To me, it is a very different analysis that needs to take place when you're looking at that type of strict application versus appraisal, which is a contractual agreement. I would say that, and again, I would point to the fact that the Supreme Court has yet to decide. I mean, they've had that opportunity in the past to decide whether they would like such a strict line to be drawn, and instead they've created this framework where we're looking at these two different aspects and allowing judges to make that determination, because I believe, given the fact that we know appraisal can be invoked post issuing, like the beginning of a claim. So you can file a complaint and then still invoke appraisal. So we've already blurred that line. So although it is a pre-litigation remedy, we still allow people in claimants to make complaints, to file complaints, and then invoke appraisal afterward.
But more often than not, the claim that they are bringing is to say, we need declaratory relief as to what the value of the covered loss is, and as part of that complaint, we hereby wish to invoke the appraisal process. I mean, you can make the argument that the claim is really necessary in order to get the court to compel the parties to go to appraisal if one of the parties is not willing to participate. Right. So, I mean, I hear what you're saying, but it seems like that the mere filing of a claim is not necessarily antithetical to the right to obtain appraisal if, in fact, the complaint asks for the court to compel appraisal.
Sure. And in this case, if we're looking to the framework that was created by the Supreme Court, we can look to number one, which in this case we're basically saying, hey, although coverage may have been accepted in this initial damage, we are now looking to this supplemental claim and whether coverage has been or hasn't been accepted there. Or in the alternative, even if we accept that coverage was extended to the original claim, we have an assignment of benefits here. So although Superior steps into the shoes of the insured, Superior still did not have a right in and of itself to demand appraisal until it actually received these benefits, until it's received the right to receive the benefits. And so we know that if we're just looking at that time frame, rather than looking at this 2+ year time frame, Superior, when it actually had a right and an obligation to demand appraisal, does that within 9 months. And then
I'm not sure how I'll be honest, I'm not sure how convincing that is given the backdrop of the law on the assignee stands in the shoes of the assignor. I think what your friend on the other side would say is, hey, no one held a gun to your head to say you had to accept this right. Assignment. You knew that there was this history. Take it or leave it, and you took it.
And I think that's why we also have case law that specifically states that, hey, the time frame is not the only consideration here. So regardless, the time frame shouldn't be the only consideration. And what we do know is that in this case, Superior, as far as litigation goes, we are only looking at a complaint and then discovery that was filed contemporaneously with that complaint, which happens in virtually every single case. And then we're looking at an amended complaint that was limited in scope as directed by and as a result of the motion to dismiss. So we are looking at very limited amounts of litigation here. And again, so the question becomes, is that significant litigation? And is it significant enough to demonstrate this waiver? And our position would be no. So although it's not as cut and dry as, hey, we file our complaint and along with our complaint, we're asking for an appraisal, I think that's, and this goes back to your question about drawing of the line. I think that the line it's very blurry, and I think it's been left blurry purposefully because the court understood that these situations arise where things are not going to line up as neatly as maybe perhaps we'd like. Next, if you don't have any further questions regarding waiver, I'd like to look at the issue of the necessity of an evidentiary hearing. On that issue, I've looked at basically every case that I could find. In fact, and I apologize, I filed a notice of supplemental authority last night.
We just got it, so
Okay.
you may want to give us the Reader's Digest version of what that case stands for.
So really the purpose of the supplemental authority is simple. It's and I'll just read you a direct quote. It's a case from the 3rd DCA. I believe it was June or July.
June.
Yep. And my purpose is this. It's the court says, we have held that when an insurer reasonably disputes whether an insured has sufficiently complied with a policy's post-loss conditions so as to trigger the policy's appraisal provisions, a question of fact is created that must be resolved by the trial court before the trial court may compel appraisal. And so I think that the key there, at least in my eyes, is this idea that the insured has to reasonably dispute these issues of fact. And so while the insured in this case points to conclusions, which are the non-compliance with post-loss obligations, the actual facts that underlie those conclusions are not present. I mean, we know that they never asked for an EUO, they didn't ask for a proof of loss, they didn't ask for any documentation. There's from my perspective, there's no factual basis that would require the trial court judge who's been practicing for 30 years to say, okay, in this situation, based on the record and based off of everything I've been presented with, there is a legitimate, reasonable factual dispute here. I think that what happened here, and as Heritage has pointed out in their briefs, we have gone through multiple hearings, multiple filings in which they've been able to express this idea or this thought process several times. And at every single point of the way, the judge has not found enough to believe that these are reasonable claims. In fact, at the December 13th, 2019 hearing, the judge even says, hey, I understand you guys need an opportunity to investigate, grants their motion for entry on the land. They have an opportunity to investigate, and we hear nothing back from Heritage. There's no further factual dispute here.
Well, Mr. Rosales, the judge made no factual findings, right, at that hearing, right? So we don't have any benefit of what the court found, if at all, if it entertained that on that issue. And to the credit of, I guess, Heritage would argue that, well, they didn't request an oath or an EU or anything like that because they weren't even aware of the supplemental claim until they got served with the lawsuit, right?
Sure, but during that time frame, what they are able to request is entry upon the land.
Yeah,
So
but
it
how
does,
did they don't, but see, to their credit, they had already made their determination on in the initial claim. And then there's this fact that sits there in the middle that I'm still trying to resolve whether or not an evidentiary hearing is required, where Superior says that they served a 14-day demand and Heritage says, well, I didn't receive it. So I'm trying to determine whether or not that's even significant enough to warrant an evidentiary hearing, or whether there are facts there sufficient without that to see that a waiver was actually that we could find a waiver based on the facts before us now.
right. You know, in my, and again, obviously I've read this several times, but the way I see the process from maybe like a more macro view is that Heritage had ample opportunity before and after they were after the order granting for entry on the land and their opportunity to investigate the claim. They had ample opportunity during that time frame, and then between when they actually finished their investigation and the entry of the appraisal, they had ample opportunity to move forward and create a reasonable fact issue here. And I think that the trial judge, seeing the circumstances and seeing this case over and over again, is in the best position to make that determination. And in this case,
Well, but to
Brody
Judge Smith's
found-
point, it doesn't look like he made a determination, and you keep adding this word reasonable factual dispute, and I'm not sure where you're gleaning that from. The case, the People's Trust, the Ortega case that you just filed actually seems to indicate, like reading through it now, seems to indicate that, look, if there's a dispute about whether or not anybody complied with a coverage obligation, in any part of the policy obligation, you need to have an evidentiary hearing before you send them to appraisal.
Well, so if we
I
want,
mean, I know you read that blurb earlier. I'm just telling you from reading the whole case, it seems like where the court ultimately lands, it seems to say, look, if there's facts in dispute about whether or not anybody complied with what the policy says, you need to construe that before you send them to appraisal, which makes sense, right?
sure, but again, if we look at those cases, and if we take a look at the individually, so in Ortega, People's Trust requests a proof of loss. The Ortegas returned an incomplete proof of loss. People's Trust then advises the Ortegas that the proof of loss was rejected because there was no attachments of the requested documentation. So those instances, those actual underlying facts, are what creates the reasonable question of whether there was this proof of loss compliance or not.
Well, Mr. Rosales, I mean, so to your point, the conflict in the record here, as I see it, one factual dispute is whether or not Heritage received the 14-day demand before they were served, right? Superior says they did a demand on the supplemental, and Heritage says we never saw it until we were served with the suit. Does that not create a factual dispute that should have been resolved at an evidentiary hearing before the court compelled an appraisal?
My position would be not necessarily.
Well, not necessarily. Yes or no? So not necessarily.
My position would be that again, given the fact that the court has dealt with this and would have seen or would have heard argument regarding this notice, the court at that time would have decided whether that in and of itself created the necessity for the evidentiary hearing, and given the experience of the judge and given the way that this whole thing played out, where the judge even recognizes the necessity for further investigation, allows further
Well,
investigation.
and yeah,
And
so to that point, I think that the court sort of just jumped over that evidentiary step and said, well, I'm just going to go ahead and order the appraisal. You guys do the discovery. And so it's kind of backwards is what happened, it appears.
and I believe that rather than it jumping over it, the court didn't see merit in the argument of the post-loss obligation questions, and
But
therefore
wasn't
didn't-
that a factual issue? Because all the facts are not undisputed.
I think at best we have a misunderstanding of whether there was notice or not within that 14-day period. And again, as Heritage points out, it's not even a factual issue, because we're talking about as Heritage pointed out, it's the testimony of an attorney. It's not sworn testimony. It's not an affidavit. So we're not really dealing with a factual issue.
Mr. Rosales.
Well, I think they're,
oh,
yeah, I'm sorry.
I'm
I
sorry.
think
Go
to
ahead
their
and answer Judge Smith's question, and then you'll need to wrap up. Okay.
Okay, just real quick, I think to their point, we have enough evidence that's undisputed to show that Superior waived the right to the appraisal. I think that's what their point is. So you can answer that.
Sure, and my point, my response would be that the judge, again, is in the best position to have gone through and seen the case from start to finish, and the evidentiary issues here don't necessarily, all the case law that's been cited has not in relation to the waiver issue. It's in relation to the compliance with the post-loss obligations. So we are looking at, as far as evidentiary hearing, the requirement is whether there is a reasonable, question of fact as to whether Superior complied with its post-loss obligations. The waiver issue is a separate and distinct issue that's controlled by other case law, not the post-loss obligations, and that it's very two separate issues here in my view.
Okay. Thank you, Mr. Rosales.
Thank
Mr.
you.
Noel, I'll give you an extra minute. You have 5 minutes.
Thank you, Your Honor. Starting with the evidentiary issue regarding the post-loss obligations, there's nothing in the case law that says Heritage has to pre-try the reasonableness of the factual issues. That's the whole purpose of the evidentiary hearing in the first place, so live testimony and evidence can be presented to the trial court, and that's a threshold issue that the court did jump over and erroneously omitted. This record is clear. There's factual disputes on the post-loss obligations. In particular, as we've already discussed, the plaintiff's position that they submitted a 14-day demand for approximately $220,000, and Heritage's position that they've stated at both hearings and throughout the entire case that there was no notice whatsoever of a dispute with the initial below deductible determination until the lawsuit was filed. And even beyond that, in the appendix to plaintiff's answer brief filed in this court, there's an additional estimate that is in that appendix, a post-suit estimate dated September 19th of 2019 for $317,000. So plaintiff's dollar amounts, estimates, and the facts in general in this record are almost a moving target. And it really does crystallize why the trial judge needed to hold an evidentiary hearing on the post-loss obligations if there was, in fact, no waiver. Moving back to the waiver argument and whether there could be a bright line rule on waiver, I think for purposes of this case, this court can put together a bright line rule by drawing from the existing case law. There's a group of FIGA cases that have been cited in the briefs, and those cases sort of lay out the different factors that would lead to a finding of waiver. The Honeywell case, FIGA versus Honeywell from this court, focuses on the fact that there were multiple complaints that stated nothing whatsoever about appraisal, just like this case. The FIGA versus Rodriguez case from the 5th DCA also focuses and discusses on the fact there's multiple complaints. So that's clearly a key factor, and it's present in this case. The FIGA versus Reynolds case and the FIGA versus Maroulis case both talk about how the party seeking appraisal, the insured, had a delay of either a year or slightly over a year. In this particular case, it's a delay of over 2 years. So that's another piece to the puzzle to go with the multiple pleadings that are silent regarding appraisal. We also have an extremely lengthy delay. Appraisal is supposed to be a process that efficiently and quickly resolves claims, and typically it would be invoked by the insured pre-suit without the need for a lawsuit in response to the initial below deductible determination if the insured or its AOB company felt that that was erroneous. The cases where you see appraisal invoked a lot after suit has been filed typically comes from the insurer, because up till that point, they haven't really been in a position where they would need to invoke the appraisal. If they fully denied coverage pre-suit, then they would have no basis to deny appraisal at that point. They would feel that they do not owe any further payments on the claim. So for a plaintiff who has control over the pleadings, unlike the insurance company defendant not in control of being sued, to choose breach of contract twice in 2 different pleadings, that's definitely inconsistent with the right to appraisal, along with the discovery requests and also the lengthy passage of time. Another case that's significant is the ARI Mutual Insurance versus Hogan out of the 3rd DCA. And that talks about a 9-month delay, even less than 1 year, when in this particular case, we have over a 2-year delay. So the fact that this is an AOB company and they didn't have the assignment of benefits from the insured immediately, again, as discussed previously today, that's not a factor because the AOB company stands in the shoes of the insured. And also the plaintiff has not explained why there was even a 9-month delay after receiving that assignment of benefits. As soon as they had that AOB, it was clear it was below deductible. Heritage had not issued a payment on the claim. At the very latest, they could have invoked appraisal at that point, and the claim could have moved forward, allowing Heritage to investigate and adjust the supplemental claim. It simply never happened. A breach of contract lawsuit was filed, and then much, much later, far after the initial coverage determination, appraisal was injected for the first time. So for those reasons, we request that the court find that there was a waiver here of the right to appraisal and reverse and remand for entry of an order denying appraisal. Alternatively, we request reversal and remand for an evidentiary hearing to flush out the facts, not only on the post-loss obligations, which are clearly contested, but also to the extent that waiver may be affected by whether there was that 14-day demand that was never received. That would also be an issue appropriate for an evidentiary hearing if the court determines that the facts in the record are not sufficient as a matter of law. Thank you.
All right. Thank you both. All right, we will take one more case before we take a break. The next case that we have set up, set for today is